You hear a lot of people talk about what their rights are. I've got rights under the Constitution. I've got rights to do this or do that. Today, we're going to talk about the 5 rights of estate planning. Hello, and welcome to another episode of Let's Talk Estate Planning. I'm Jim Miskell. This is the podcast where I'm pursuing my dream that everyone has estate planning that protects their family's future and peace of mind and makes them sleep a little bit easier at night, making sure that they've got everything taken care of so that when grief and crisis occurs, your family isn't left scrambling trying to figure out what the heck is going on. So here's the deal. I appreciate you joining the podcast. The podcast is information and education, hopefully a little bit of entertainment. The issues we talk about are really important, but it does not constitute legal advice. You shouldn't take action on anything you hear in my podcast or anybody else's. That's where meeting with a qualified professional to get legal advice about your situation is really important. So this is the disclaimer. I'm a lawyer. You knew I was going to have a disclaimer. Information and education and hopefully a little entertainment. That's what the podcast is all about. When you need legal advice about your situation, you need to get that from a lawyer representing you. Whether you meet with them virtually or in person, that's the next step. That's my disclaimer. Now back to the podcast. Everybody's got 5 rights of estate planning. Demand your rights. These are actually 5 things you've got to get right, or your family will be unhappy with what you've done and how you left it for them. So the first right to address in estate planning is people. First thing you got to get right is you've got to choose the right people, because estate planning in large part is about authority, making sure that there is access and control of assets. When you're alive and well, that's easy. You've got that. What happens when you become disabled? That's where you need to make sure that you've got the right people in the right seat so that they can control and access those assets on your behalf to make sure things don't fall apart. And that's really where the things can fall apart really quickly for families, not even with death, but with disability that comes into play, can wipe out savings. There can be just large costs and inefficiencies when the planning hasn't been done ahead of time. So you got to get the right people in the right seat. You got to find people that you know and trust, who know and love you and will do the right thing. So that's the first right. Second right you've got to get is authority, making sure that the people that you choose actually have that authority. What kind of authority are we talking about? Well, it really breaks into 2 categories when it comes to estate planning. And the first is legal and financial. Those 2 always seem to go together. Legal and financial authority that you could convey in a power of attorney. So that's one kind of authority. And the other kind of authority is over your well-being, your health, your medical. So that would be a healthcare agent. You see those appointed in healthcare proxies. In some states, they call them healthcare proxies. Sometimes they're referred to as healthcare powers of attorney. In Georgia, we talk about an advance directive for healthcare that appoints your healthcare agent. So that's the first thing. People. You got to have the right people appointed. And then second, right, you got to give them the right authority. The people, by the way, could be family members. Can be, as I said, first level you always think about is someone that I know and trust who knows and loves me. I may not have a good cast of characters there, because it's not just enough that they know and love me and they want to do a good job. They've actually got to be able to do a good job. And sometimes you may not have somebody that's capable of doing that. Your son, the EMT, is a perfect healthcare agent. No problem. That's who you want all day long. Great kid, super trustworthy, would do anything in the world, but is lousy with money. Never balance that checkbook. He's not going to be your power of attorney agent. He won't be over the legal and financial things because it's just not in his wheelhouse. The alternative to using lay people, just people in your family, would be hiring professionals. It could be CPAs. It could be professional agents. Daily money managers is an example of that. CPAs, anybody that acts with a fiduciary duty, meaning that their duty is not to themselves, but to the person that's appointed them to act on your behalf. So if there's a hole in the coverage you've got with your cast of characters, you can fill that with a professional. So we've covered our first 2 rights. Our third right, after people and authority, is time. time or timing, making sure that the authority attaches to the people that you've appointed at the right time. If they've got the authority, but they don't have it when they need it, it doesn't do them any good. What am I talking about here? I'm talking about, for example, powers of attorney. I review financial powers of attorney for folks all the time who bring them in, and I craft a lot of them for folks as well. There are broadly two choices on how you set those up, and one is a power of attorney that's immediately effective when you sign it. That's what we tend to use more often. I tend to see those more often. The second type is what's often referred to as a springing power of attorney. Sometimes it's called a contingent power of attorney. It says this power of attorney comes into effect only upon the occurrence of another event. Usually it's disability. So, if I lose it, then you can be my power of attorney. But until I'm crackers, you have no reason to act, or no authority really to act. The difficulty with the springing powers of attorney that I've seen in use is who says and when. What do I mean? I mean, who says that I'm no longer competent? Well, the power of attorney may say you have to get written evaluations from 2 doctors. That can work. I've seen that work for some families. I've seen some families have some trouble with that. Why? Because incapacitation is not a diagnosis. It's not a prognosis. It's a legal determination. Doctors don't do legal determinations. That's judges and lawyers. Prognosis and diagnosis is what they do. They can tell you Alzheimer's, they can tell you the common cold, but can't very often are reluctant to go so far as to say this person is no longer capable of managing themselves or their assets. Some doctors will. I've seen some families have trouble with that. And when that fails, the family is faced with a situation where they're going to have to get in front of, well, in Georgia, it's a probate court judge looking for a determination of incapacity, or rather a guardian or a conservator in those proceedings. That is not what families are looking to do. Families just want to be able to get the IRA money to pay for the treatment. Families just want to be able to do the reverse mortgage or pay off the mortgage or do whatever needs to be done. The springing power of attorney, although it can make a lot of sense to some folks when they sit down to do it, can cause problems later that are unanticipated. The other problem that I see with those is when the agent goes to the bank. Let's say you got the 2 letters from the doctor, 2 doctors, you go to the bank, you're the agent, the teller, he's never seen anything like this. He says, all right, I'm going to go to the branch manager. Branch manager calls legal. Legal's going to ask you to send it. It gets sent. They take a while looking at it. Oh, I don't know. Come back. Can the person who made the power of attorney sign our cover letter? We have a form we like to use at the bank. It's our power of attorney. Can they? Sure, that's no problem, except the person who made the power of attorney is in a coma. Mom's in a coma. She can't sign. So timing, very important. The plans that work best convey authority right now. One of the things that's really important for folks to understand that makes them feel more comfortable about this is that when you appoint somebody as your power of attorney agent, you give somebody power of attorney, you're actually not giving up any power yourself. You're just extending your power to someone else. You still have all the authority in the world, can still make all your own decisions. They're only there to help if you need them to. And back to something I mentioned earlier, they're bound by a fiduciary duty. So if somebody uses your money under the power of attorney to do things for themselves, they've got civil exposure, perhaps criminal exposure. It's problems for them. So you got to have people you trust. You got to give them the authority they need, and it's got to be effective. The timing's got to be there. So those are the first 3 rights: people, authority, and time. Hey, Jim Miskell here. Sorry to interrupt the episode. Hope you're enjoying today's content. A lot of times when folks are thinking about this kind of thing, questions spring to mind. If you have questions, we like to do some question and answer episodes. So you can go to our website, letstalkestateplanning.com, and shoot us a message and say, hey, on the podcast, I'd like Jim to cover this on the next question and answer session. Or if it's hitting closer home, especially if you're a Georgia resident, Of course, we can't give legal advice on the podcast because it's not specific for your situation. But if you got a situation that you need to handle, it's important to get that done. So let's talk estateplanning.com is how to contact the office. I'd love to talk with you about the specifics of your situation and make sure your estate plan is everything that your family should have it be. In the meantime, we're going to go back to the episode. Thanks for tuning in, and I hope to talk to you soon. Number 4 is instructions. And that's the fourth thing you've got to get right with estate planning. Your fourth estate planning right is instructions. That's making sure that the people you appointed in your first right have a very clear idea of what you need them to do and how you want it done. What are your values? What's important to you? How is that to be carried out? Very often you see, well, a great example of this is living wills. If I'm gravely ill, here are my treatment preferences. This is what I want you to do. I want you to extend treatment for as long as possible, no matter the outlook. Or if I'm gravely ill, you can withdraw treatment. If my death's going to occur anyway, go ahead. So, that's an example of making sure that your agent has the authority. An advanced directive for healthcare has that living will piece built into it. So it makes the appointment of your agent as well as the direction. So that covers the healthcare part. What about the legal and financial? Well, powers of attorney are long on authority, but they're short on instructions. They don't really tell your agent what's important to you or how to do it. They just say, here, my agent has the authority to take a mortgage, pay off a mortgage, to withdraw money from my IRAs, to fund things, to borrow, to build a trust for me, whatever it may be, but not how to do it. That's where a successor trustee under a trust, that's where that arrangement can have an advantage for folks, because with a trust, you've actually got a rule book that says, you're now my trustee. Here's how I want things done. So not only do they have the authority over the trust power, your trustee would have the authority over the trust property. They would also have instructions about how to manage and distribute that trust property. Different from a power of attorney that gives the authority, but not the instructions. And then instructions at death, a will, pretty good at that. Trust, pretty good at that also. So either way, you're with the case of a trust, it's your successor trustee. With the case of a will, it's going to be your executor. You've given them a roadmap to follow. Of course, if you don't give them a roadmap, they're going to be stuck with whatever the state statute on intestacy is. Basically, if somebody doesn't leave plans, how does their estate get divided up? So that's why it's really important to have your own instructions, because what the state statute says may not be what you want. I meet with a lot of folks who say, I know we should have gotten, couples very often say, I know we should have gotten around to this before because we've got these kids. We've been meaning to do it, but we always knew that it would be okay, that if something happened to one of us, the other spouse would inherit everything, could take care of the kids, no problem, and would be all right. May have to go through court. And, in Georgia, that's just not so. That's not the way it goes. Under the state statute, the intestacy scheme, it goes in equal shares to the kids and the surviving spouse. And that includes all the children of the decedent, not just the children with the current spouse, but also children from prior relationships. So there could be stepkids, adult stepkids, ends up with everything in the event that one of them passes away. So the instructions are critical to make sure that what's important to you gets carried out. So far we've got 4 rights covered. You got to have the right people. They've got to be trustworthy. They've got to be capable. They can be lay people or professionals. You got to give them the authority they need. You got to give it to them at the time that it's important for them to have it. You got to give them the instructions to carry out their duties. And finally, you got to work with the right professionals. What do I mean there? I just told you this, how I met with couple after couple after couple who said, we should have gotten a will, but that's okay. We understand how the statute works. And if we didn't have a will, it was still going to be okay. Newsflash, they didn't know how the statute would work. The law covers everything, but it probably doesn't do it exactly the way you think it does. Most people have a pretty good idea about some things, but it can surprise you. And so that's why it's important to work with folks that are familiar with what you're dealing with. Why? Because it's complicated. You do your job. You do the things you do. You're familiar with what you do. You may not know what you don't know. And I'm not talking exclusively about estate planning attorneys. That's why you have financial advisors who can direct you to the right financial products, the right investment strategies, the best philosophies going forward on that. Tax professionals, your estate planning attorney, unless they're also a tax professional, is probably shouldn't be your end word on what the best tax move is. Estate attorneys are great at spotting tax issues, but you should always have a tax professional with the final word. Same CPAs, tax preparers, those sorts of things. It's really best to have a team approach to make sure that what's important to you gets put in your plan in the right order, help you sort those priorities and make sure that it gets done right. We do probate, and I'll tell you, we make a lot larger fees on our probate cases with the do-it-yourself wills. Those that folks have tried to create themselves, knowing full well that they knew what the law was. Usually there are extra complications. Very often, much more often, there are extra complications and extra court fees, extra attorney costs, and more hassles inside the family when folks have sort of done it themselves. Oh, I know how this works. Maybe you do, maybe you don't, but it's important to work with a good team to make sure you cover all those bases. So those are your 5 rights. You got to have the right people in the right seat with the right authority at the right time with the right instructions. The best way to do it is to work with the right professionals. If you get all those 5 things right, when grief and crisis strikes, your family is going to have more time to spend on what's important. And that's time with each other, and less time is going to be taken up trying to figure out what the heck's going on, going through administrative functions, spending time at the courthouse, having to track down doctors. And, if you take care of it, it makes it easier for them later. So if you get those 5 things right, your family's going to feel like you got it right. And if you don't, they're not going to be very happy with what you do. So those are the 5 rights of estate planning, not the rights you have, but the things you've got to get right for your family to have a secure and a better future with less conflict in it. Thanks for spending a few minutes today talking about estate planning. It's my dream, of course, that everybody has estate planning so they sleep better and their family does better in times of grief and crisis with less conflict going forward. I'm Jim Miskell. Thanks for joining us, and look forward to talking to you again soon.